Today the court will have to rise at 12:30 because we have a meeting at the new High Court site. Justice Michael is here, so we'll have to rise at 12:30.
There is one matter.
Yes.
Not inconvenience, supplementary item number 3. There is some urgency in this matter. Yesterday,
Oh, the Passover matter.
I'm sorry, ma'am.
Yesterday it was
If
Passover.
Your Lordship takes up that matter. And one
28.
matter I came with my learned friend.
Yeah, these are motion matters.
Yes,
so
motion
obviously
matter.
it will be called out.
Only one may not possible. I came to know about the list in the morning. I just requested my learned friend to let
Okay,
it come
we'll
up
take
with-
up only the motion matter.
Yes, a motion, that is in motion.
Oh, yes. Item 1.
Item 1.
Oh.
1.
Because there is one in the daily list and there's one motion in the supply list also.
So one may be
Item 1.
one taken
So
some
which one
other
do you want?
manner, supplementary manner.
Supplementary one?
Yes.
Okay. And the motion in the daily list
That
can be
let me
taken up?
till any date, my lord.
Yes, yes.
Yes.
Yes, yes.
Deeply of place, my lord.
Ladyship, I beg to mention item number 22.
22, yes.
If it may kindly be listed on Tuesday, if my ladyship can kindly accommodate. I've taken the consent of the
Okay. 22.
22. Yes, 22.
Tuesday.
Yes, Tuesday, ladyship.
On Tuesday.
22. Yes. Lordship.
Interim may be extended.
The interim order passed earlier shall be extended to the next. Yes.
Lord, I beg to mention item number 16.
16.
Item
Yes.
16.
Lordship, I am for the petitioner. Well, its last order may kindly be seen. This is the order dated 24th of, this is last order minutes, 21st of August. Last opportunity, very reluctantly, was allowed to the state to file the reply. But the petitioner is suffering. He has retired and he's saddled with all his retirement benefits are on hold, and they are not even filing reply millets.
Lordship says they have filed an additional affidavit, Lordship.
Well, that is only one official document that the court directed us to file an affidavit. That is a letter written by the state government to the accountant general that they are not accepting the contention of the accountant general. That is their letter, millets. I don't have to do it against them.
Final opportunity was
Lordship.
given actually. Yes.
My lords.
You are yet to receive the instructions.
I'm yet to
also.
receive instruction.
What
So
happened?
if Lordship, I'm allowed 2 weeks time, Lordship. I have communicated to the respondent
You
authority.
call them personally, call them up. Otherwise, you tell them that the court will call them. They'll
Lordship.
have to
That
appear.
will be,
Lordship,
my
you-
lord can record
Lordship,
it, that if they do not appear, the some senior officer will be called on the next date of hearing. That
Lordship,
will help my brother also. He can send the order that court has taken very strong view.
Lordship, in fact, I have communicated to the respondent authorities,
Okay,
Lordship.
okay. Heard learned counsel, Mr.
SK Srivastava military.
B, 1 minute. Victor Zimomi for the state respondents who has prayed for 2 weeks' time to receive instructions and to file counter. Stop. On 21/8/2025, this court had allowed 2 weeks to the respondents to file their affidavit in opposition as a final opportunity. Stop. However, the said prayer has been made again today when the matter is called. Stop. Learned counsel for the petitioner, Mr.
SK Srivastava.
Srivastava is present and has objected to the said prayer for adjournment. Stop. In view of the fact that several adjournments have already been given and a final opportunity was also given by this court on 21/8/2025, it is made clear that on the next date, if the affidavit in opposition is not filed, the concerned officer will be summoned to appear before the court to explain the delay. So accordingly, list the matter.
After 2 weeks.
After 2 weeks will be,
Let that not be fixed.
will
The date may be left
on a date to be fixed by the registrar. Yes.
grateful minutes.
Yes.
Grateful minutes.
Much of it.
Yes.
Lordship, I also beg to mention item 19, Lordship. Here on for the state respondent, Lordship. Lordship, I'm allowed 3 weeks time to file my affidavit.
3 weeks.
Lordship.
Okay, where's the petitioner? Have you obtained consent?
No, Lordship. Petitioner, yes, Singha.
Okay, Jolene. Can you just give a call or something and then come back again? Okay? Get the consent at least. Yes.
Please, my lordship.
Yes.
Lordship, I received affidavit in reply, affidavit in opposition of the respondent number 2 just now.
Which case?
Item number 2214.
Lordship, I filed my counter affidavit this morning and I've also served the copies.
Item number 2 to 14.
2 to 14, yes.
Item number 4. In item number 4, I've filed my counter this morning. I'm representing respondent number 12.
No, in all the petitions you have received, or only item 4?
Only in item 188, because this honorable court directed for filing only in one.
Okay. Learned counsel for the petition.
In 188.
Submits that she has received a copy of the affidavit in opposition in respect of the respondent number
12.
12 this
UGC.
morning. This morning.
Lordship,
You would like to file a reply? Or
if any, it can be listed either next week or any fixed date. And Lordship, I pray that this case has been dragging on for such a long time
yes.
because of the respondent number 12 not representing. Now they have come and I may or may not file. Kindly list the matter fixed for hearing. And Lordship, I also pray that
And in the other petitions, pleadings are complete?
everything completed. On 11/7/2024, this Honorable Court has even made it clear that if no affidavit is filed, this court shall, on the next date, proceed with the case on the basis of materials available on record after imposing cost. Cost has also been imposed, and this is ready for hearing, Lordship.
Okay.
So
you'd
next
like to
week's
keep
date,
it for admission hearing, or will list it in the admission column, in the hearing column?
admission hearing will be more immediate, Lordship. Or
Received this morning, no? Stop. As the pleadings are complete, list the case for admission hearing after 2 weeks.
a fixed
And-
date may be given,
after
Lordship,
2
so
weeks.
that everybody will be. On 22,
After 2 weeks will be actually 26th, but we can
On
put it, we
22
can
will
put
be-
it on 25th. 25th.
in case this case, if everybody wants to submit, then it might take more than 1 day, Lordship. So maybe on 22 and then some hearing.
Okay, list the matter on 22nd September for admission hearing. And in the meantime, if the petitioner is also allowed to file the reply, if so advised. Yes.
Lordship.
Obliged.
Obliged, Lordship.
Yes. Any more
Yes,
adjournments?
Lordship.
Yes.
Lordship, I beg to mention item 23.
Item 23, yes.
Lordship, I have instruction to be on behalf of respondent number 2 and 3. And I'm filing my Bagaladamana during the course of the day.
Okay.
So may I plead that Lordship, this matter will be listed on 18th next week for consideration of IA, that is for continuation.
Heard Learned Counsel Mr. Wati Jamir, who has submitted that he has received instructions to appear for respondent number 2 and 3. And he would like some time to file his objections to the prayer for condonation. Stop. Learned Counsel for the appellant as well as the Learned Counsel for respondent 1, 4, 5 and 6, Mr. Apok Pongono are present. Stop. List the matter on?
Next week, Lordship,
List the matter next week.
on 18th.
Yes. 18th. List the matter on 18th. Yes. Yes.
As important, Lordship, in item number, in writ petition 340, interim order may be continued.
Only in 340.
Yeah, in 340.
Okay. WPC 340 of 2022.
Previous-
That is item 3. The interim order passed earlier shall continue till the next date. Yes.
Obliged.
Maybe, Sir Lordship. Lordship, I beg to mention item 20, Lordship.
Item
On behalf of Divika, Lordship, if this matter can be posted on Monday, I've taken the consent, Lordship.
On behalf of Livika,
Yes, Lordship.
heard Learned Counsel, a message and such, who makes a mention on behalf of the public prosecutor, Ms. Livika, who is appearing
Your
this
Lordship,
matter.
interim may kindly be extended
Yes, stop. She has prayed for listing the matter on
on Monday, Lordship.
on Monday, 15th. 15th, stop. Learned Counsel for the petitioner is present. List the matter on 15th September. The interim order passed earlier shall continue till the next date. Yes.
Lordship, I have seen the prayer for item 21 as well, Lordship.
Okay, 21 also same. You're reappearing? Okay.
Yes, Lordship.
Okay, same petitioner's name? Yes.
Much obliged, Lordship. Much obliged.
May please, Lordship. I beg to mention item number 24 and 25. The arguing counsel have difficulty today. If the matter can be listed after a week. Okay, after 2
Who is it? Mr. Eliralu?
R. Iralo.
Okay. Third, Learned Counsel for the petitioner, MS such, who has submitted that the leading counsel, Mr. R. Iralu, is indisposed and therefore prays for listing the matter
After 2 weeks.
after 2 weeks.
Your Lordship, I'm for the respondent in
Oh, you are mentioning for the respondents?
in review petition.
For the respondent, okay. Okay, this is filed by the government.
Yes, yes.
Okay. Learned additional AG, Ms. V. Shukri is present and has no objections. So that your senior is R. Iralu or L. Iralu?
R. Iralu.
R. Iralu, okay, that is okay. Yes, after 2 weeks.
Much.
For motion, item number 1. I beg your pardon. For motion, item number 26.
This is an application for bail, my lord.
Let them take time to get the CD.
My lord.
When can you introduce? After a week?
Yes, after a week.
If it can be on Thursday or Friday, if a date can be fixed. I intend to take a different date for the next application.
Friday, Your
So
Lordship.
this can be on 19th.
My lord.
The next one also, same.
Next one, it can be on 20,
Next
on
one can
22.
be on 22nd then.
My lord.
First one, okay, bail application submitted. This bail application is filed by the petitioner, praying for, this is an application under section 480 of the BNSS, praying for release of the alleged accused on bail. So, heard learned counsel for the petitioner, Mr. Sinti Younger. Stop. Also heard Ms. S. Mary, the learned public prosecutor. Stop. List the matter on 19th September for hearing, on which date the learned public prosecutor shall produce the updated case diary. 27.
Item number 27.
What's okay?
Same. 27. Same order here also, but this one will be fixed on 22nd. Yes.
Deeply obliged.
For motion, item number 28.
Yes.
Lord, at the outset, may I make one request, my Lord? I am led by the learned Additional Solicitor General, Mr. S.V. Raju. He is on his legs in Supreme Court, so he requested if this matter can be taken up at 12 or 11:30 or 12, my Lord. Just postpone it by an hour. I am conscious that the bench is only till 12:30. So, my Lord, a request, because I am led by my senior, Mr. S.V. Raju, Additional
One thing, my lord, let him argue at 12 o'clock, no problem. Can I place my case so that it become easier?
In his absence, it will be a little difficult, Mr. Das.
My pen is there.
You are there. You record.
Yes,
You
you
record
can
the
note down.
submissions.
Otherwise, we are
I can
wasting
record,
time.
my lord, but Mr. Raju is actually logging in from a different place. I will not be able to brief. Therefore, I am only seeking a short, an hour, my lord, only.
My lord, what will happen?
Because at 12, if the submissions go on for a long time,
11:30 also, if my lord can accommodate us. He's right now on his legs before the third court in Supreme.
My lord, what will happen?
Yes.
In this case, I have to go a bit slow. Why I am saying it will take some time. That's why I am requesting your lordship. If your lordship can just hear it, because no effective order will be passed unless your lordship hear the other side. My learned friend can note down. There is no problem. Because it will take some time. I am telling your lordship. Because what will happen? 12:30.
otherwise, just a bare perusal, you are challenging the production warrant.
Yes, my lord.
How can you challenge the production warrant?
I am telling you. My lord, your lordship knows any production warrant which is issued, it is always by filing an application by the authority, police authority concerned. There is no application which has been filed. And secondly, kindly see, my lord, I know that your lordship will put a question to me how a production warrant can be challenged.
Yes, exactly.
My lord, kindly look into it. First, my lord will kindly have to see the production warrant at page 40 is the order. Kindly see 40 as the order, which has been put to challenge. Lordship has look into it.
DSP Central.
This is 29/8/2025. Received letter from DSP Central Jail, Tihar, New Delhi, requesting this court to issue production warrant for the next date of hearing. Hence, issue production warrant to produce the accused Bhupesh Arora before this court on 16/9/2025. My lord, now your lordship will kindly see 302 of BNSS, which is 267. Of the CRPC, now its BNSS is 302. Correspondent is 267.
It's almost the same. I
All
think.
same. I'll just read it slowly, my lord.
Yes.
302. Oh, you don't have a book.
I think it should be there.
Yes, no, it's okay, no problem. I'll just wait for that. Well, I'll just tell your lordship that what has happened in this case before your lordship looks into production warrant. First submission will be there is a violation of the High Court's order, which is now pending before this court. Violation of the High Court's order, 1. Number 2, my lord, the ED tried to, in a circuitous manner, after the rejection of the order passed by this High Court, after hearing it. Now I'll tell that. Kindly see 30 CRPC,
No, this is BNSS.
BNS. Kindly see 302. CRPC will apply, but BNS is almost same, BNSS.
Yes.
302, power to require attendance of prisoners. Lordship got it?
Yes, yes.
Whenever in the course of an inquiry, trial or proceeding under this so and so, it appears to a criminal court, A, that a person confined or detained in a prison should be brought before the court for answering to a charge of an offence. It is not a charge of an offence, or for the purpose of any proceeding against him. So it is for the purpose of any proceeding against him. Now, my Lord will kindly see B, that it is necessary for the end of justice to examine such person as a witness. The court may make an order requiring the officer in charge of the prison to produce such person before the court answering to the charge, or for the purpose of such proceeding, or for giving evidence. Now, my Lord, there has to be an application under 302 for a production warrant. Whatever may be the reason, there has to be. There cannot be any request, number one. There cannot be any order in a suo motu. There has to be some application filed. Now, if your Lordship now looks into the first application that was filed by the ED is at page, Lordship will kindly see at page 99. This is the first application that was filed on 4/8/2025. Kindly see that page 99. Lordship got it?
Yes.
IA, kindly see on the top. Kindly see the IA 465/25 in money laundering case 1 of 2020. Lordship got it?
Yes.
Now your Lordship will please mark IA. That's a very relevant. I will show why I am showing this IA. IA 465 of 2025. Now if your Lordship now turn to one paragraph is very important, which goes against the judgment of the Supreme Court.
Lord, only
See at
one
page,
learned
Yes.
Learned ASG is in the lobby if the courtmaster can permit him his entry. He is joined, my lord, if he can be permitted. The solicitor, the learned solicitor, my lord. He is here.
Just join. They can just join. Yes, yes.
He is joined.
Yes.
Deeply obliged, my lord.
now my Lord will kindly see at page 125, para 33.
125.
125
Yes.
of the entire application. See 33. That in view of the foregoing facts and the reasons elaborated, the custodial interrogation, kindly mark, the custodial interrogation of accused Bhupesh Arora is not only desirable but indeed indispensable for uncovering the full dimension of this money laundering case. It is worth noting that in a complex economic offences of this nature, effective interrogation can be crucial to gather evidence that cannot be obtained otherwise. Here, the accused is effectively the hub of a sophisticated financial crime web involving scores of entities, cross-border transaction. Only a thorough, unhindered interrogation can peel back the layers of this conspiracy. The further investigation is a critical juncture, and securing the accused's presence for questioning under custodial interrogation will significantly and in achieving the objective of the PMLA, namely identifying, confiscating all ill-gotten wealth and bringing the offenders to justice. Now kindly see next page at page 126, the prayer. 1. Issue production warrant. Kindly see the prayer. Issue production warrant for C. Bhupesh Arora, which is the petitioner, with direction to the jail authorities, Tihar Central Jail, Delhi, to produce the arrestee before this Honorable Court under Section 267 CRPC, Section 302 of BNSS, which is the correspondence, read with Section 65 of the PMLA, as custodial interrogation of the accused is required in the interest of the investigation in the instant PMLA case. Now, on the basis So now, my lord will kindly note down, they are seeking my arrest, custodial interrogation. Kindly note down. Their production is for the purpose of custodial interrogation. Whether now your lordship kindly note down whether they can do it under the relevant provision of law, which is laid down a judgment of the Supreme Court. Tarsem Lal. I'll show it. Now, my lord will kindly see the order on the basis of an application which is filed by the ED. Your lordship has looked into it on 465, that is page 99, which I have shown.
65 of 25.
That which I have shown just now, IA 465 of 2025. What is the order that has been passed by the court at page 36? Kindly see now. 36.
This is money laundering case.
Yes, this is IA. Kindly see his IA 465, same IA 365, 465, and page 36 is the order. Kindly see the order.
Page 36.
This is page 36 is the order. So your lordship is asking that whether
This is IA 465.
yes, your lordship was asking me that why a production warrant cannot be issued, whether it should be on a basis of an application or on a request which is made by the Tihar Jail Authority without any application by the ED. That's the reason why I was saying. Now this order, this is not, kindly see at page 36, 4/8/2025 on the basis of IA. Receive application registered as IA 456 of 2025 from the complaint ED so and so along with so and so. It is 465, it is not 456, it is wrongly typed.
It should be
465 it should be. 465 because IA is 465.
Yes.
Now the instant application is filed under section 302 BNS as read with 65 of the PMLA seeking production of the accused before this court for the purpose of custodial interrogation of accused Bhupesh Arora. It was submitted that the accused have been implicated in connection with the instant case being ECIR number so and so, dated so and so under section 3 and 4, and also in connection with cybercrime PS case number so and so. However, till date, the accused person could not be arrested for the purpose of investigation. Hence, he has fled from India and he has failed to appear before the IA despite summoning the accused on 13/1/2023 so and so. It has come to the knowledge of the investigation agency into the accused Bhupesh Arora is presently under custody of Tihar Jail, Delhi. In connection with present case, request the custody of the accused for the purpose of investigation. I have considered the submission of learned so and so. Peruse the applicant satisfied. Accordingly, application is allowed. Issue production warrant directing Superintendent of Tihar Jail, Delhi to produce the accused before this court on 11/8/2025. According application so is allowed and disposed of. Now, my lord will kindly note down this order on 4/8/2025 could not have been passed without hearing the accused, which it is an ex parte order. It is a violation of the principle of natural justice, which Supreme Court also one judgment, we said you cannot do it once the cognizance has been taken. You cannot do it. This is absolutely viable. Now what has happened thereafter? My lord, at page 128 kindly be seen. Now, thereafter we file an application for recalling of this order. Now your lordship will kindly see what was the order passed when I went to the court later on for recalling of that order. At page 38, kindly see page 38. Date kindly be note down, my lord, 29/8/2025. This is the same which we challenged by way of impugn order. Now kindly see, this is my recalling. IA 483 of 2025, taken up for hearing. Learned so and so present for the complaint ED and learned counsel Amit and so and so present on behalf of the instant application.
1 minute.
Is
So
faced.
IA 483 of 25 was filed by you
Yes.
to recall that order.
Correct, 4/8/2025 order. Annexure 1A, page 38. 1A, page 38. 29/8/2025. IA so and so taken for hearing, learned so and so. The instant application is filed under section 72 of CRPC corresponding so and so for cancellation, recalling of production warrant issued against accused Bhupesh Arora. I have heard the counsel. This court has issued production warrant to produce the accused by order dated 4/8/2025 on 11/8/2025. However, on account of the Independence Day celebration, the Deputy SP Tihar Jail by his letter dated 9/8/2025 expressed his inability to produce the accused on 11/8/2025. Now kindly see, next is very important. Since the accused could not be produced on 11/8/2025, the order of production dated 4/8/2025 has become infructuous. So also the present petition for recalling cancellation of production warrant, in the result the IA 483/25 is hereby disposed of. So my lord, the application was filed by the ED on 4/8/2025, your lordship has noted down, for production of the accused for the purpose of custodial interrogation and to produce the accused on 11/8/2025. But on 4/8, we filed an application for recalling on 29/8/2025. But the learned judge said, no, that has become infructuous because the accused Bhupesh Arora could not be produced on 11/8/2025. So it was not disposed on merit of the case. It was disposed of because it has become infructuous. Because he could not produce on 11/8/2025. So this is 4/8. Your lordship will note down 4/8/2025 application has become infructuous. This is what the court said. Now kindly
So,
see.
which means that the production, that order issuing the production warrant, according to the trial court, became infructuous, so disposed of.
Right, that's the case. Now my lord will kindly see at page 128. See 128.
After that, did the court issue a fresh production warrant again? Issue any fresh order after that?
No, what has happened, kindly see it. No, please see 128. No order on an application file. Kindly see page 128 now. Now the learned trial court said that this has become infructuous. Your lordship has seen that. Now see at page 128. This is from the Office of Superintendent of Prison, Tihar Jail. Now subject, kindly see, regarding the production warrant in respect of so and so in case number so and so. IA, kindly see 465.
465.
Right, so got it? 465?
That old one.
Yes, old one. 465. This is reference in the order dated, this should be 4/8/2025. Passed, and it is not 4/8. Passed by the Honorable Court of Learned Principal Session Judge Dimapur, Nagaland, directing therein to produce the above mentioned accused before this Honorable Dimapur on 11/8/2025. Lordship got it? Correct, my lord? That 4/8. In this regard, it is submitted that as per Delhi prison rule number so and so, we can produce the accused for outstation cases only after taking necessary permission from the concerned Chief Metropolitan Magistrate. Therefore, according to the order dated 8/8/2025 passed by the concerned Chief Metropolitan Magistrate, wherein the court has directed to produce the said accused through VC. Hence, the accused could not be produced physically. So, no trial court order, your lordship has seen that. Independence Day. It was an Independence Day, that is why it could not be produced. But here they said that yes, you can be produced, but it can be produced to VC, whatever may be the reason. Further, it is submitted that recently this officer received order dated 26/8/2025 passed by the Honorable Court of Special Judge, Rose Avenue District Court, New Delhi, on so and so, Bhupesh so and so, wherein the court has directed to produce UTP Bhupesh Arora so and so before the Court of Special Judge as and when the production warrant are issued by the concerned court. It is pertinent to mention here this office has not received any production warrant regarding next date from this Honorable Court. Therefore, this Honorable Court is humbly requested to kindly issue the production warrant for the next date of hearing to produce him before this Honorable Court accordingly. So
This letter is dated
dated is 28/8/2025. Kindly see, sign on the,
28/8.
kindly see on the, my 28, on the sign, bottom minor, sign, 28/8/2025. Please mark it. This is a letter which has been issued by the Superintendent of Police. It is a suo motu letter. Now, this letter, on the basis of this letter, kindly see the order passed by the learned trial court. Impugn order is at page 40, kindly see, my lord. Page 40. Now, kindly see the date, page 38. Kindly see at page 38 for a moment.
29,
Yes, kindly see, for a moment, kindly see the date of it.
8,
Page 38.
28/8.
Now, my lord will kindly see at page.
Okay, so in view of this letter,
Yes,
this order has been passed.
correct, right.
28/8, 29/8.
So there was no application under 267. Without any application under 267, my lord, on the basis of request which has been made, on the basis of that, this order has been passed. And on the same date, kindly see at 38, page 38. And in infructuous order, your lordship has seen at page 38. Kindly see first 38 and see at page 39. See page 39. See page 39. Kindly see page 39. Since the accused could not produce on 11/8, the order of production dated 4/8 has become infructuous. Present petition recalling. So this, kindly see on the top IA 485, which has now become infructuous. And on the next 40, on the same date, kindly see on the letter which your lordship
So
has
you're trying
redeemed.
to say that this letter from the jail
Yes.
is actually based on that old
Right,
petition,
right.
IA 465,
Yes.
which had become infructuous.
Infructuous. And on the basis of that, page for one hand, the learned trial court is saying has become infructuous. It is not me who said, the learned trial court judge has said at page 39, it has become infructuous. Kindly see at page 39. On the same date, on 29/8/2025. And at page 40,
Page 40.
now see
Oh,
40.
yeah, the order, yes.
On the same date,
This order.
29/8, receive letter from so and so requesting the court to issue production warrant on the next date of hearing, hence issue production warrant to produce the accused Bhupesh Sahara on discount on 16/9/2025. One hand, my lord, an application filed on 4/8/2025, that application has become infructuous on 29/8/2025, and on the other hand, same date 29/8/2025, the learned trial court is saying giving effect to an infructuous order, that is on 4/8/2025. This is what we have been challenging. Now, my lord, there are other points which is most important. More than this, my lord has asked me why not a production warrant cannot be issued. Your lordship can look at it.
Yes.
Your lordship can ask me some.
Let me
there.
see your prayer. Let me
Yes.
just see your prayer.
Yes, yes. My prayer is page 31. Page 31. See, my lord.
Why do you want this order dated 29(8) also to be quashed?
Yes, because of
When-
the page 40 for the production warrant.
No, no,
impugn order.
because the court in that order said that it has become infructuous, so no need.
No, there's page 40. I am challenging page 40. On the same date.
Oh, okay. No, because in your prayer you said disposing the said application
Yeah.
on the ground that the order dated 4/8/25 had become infructuous.
Yes.
Whereas 29(8) doesn't say that. You come to 29(8) order.
Yes.
It only says receive letter such and such, hence
Yes.
issue production warrant. That's all.
No. Hence issue production warrant. So, my lord,
Yes.
two orders
29(8).
are passed. Page 38, kindly see. Two orders are passed at page 38.
Same
20
day.
Same day. Kindly see the date. Two orders. One hand, my lord, the learned trial court knows.
29(8). 29(8). This is also 29(8).
Same date. The learned trial court knows that 4/8/2025 has become infructuous. So on the basis of infructuous, how at page 40 the application can be this on a request made by the Central Jail Authority that the production warrant to be produced on 16/9. Two orders on the same date on a basis of page 128 where there's a IA 465.
So, by this order, first order of 29(8),
Yes.
your IA 483 was disposed of and IA 465 was also disposed of, isn't it? 465 also, because in 465 they had prayed for the production warrant.
Yes.
So now the present, since the accused could not be produced on 11(8), order for production dated 4/8/25, which was on the basis of that IA which they filed, has become infructuous.
Yes.
So which means that become infructuous and your petition also infructuous.
But when you are requesting, kindly see at page 128. 128. 128.
No, praying for quashing of this, okay, fine.
Yes.
But the order 29(8), where the
Yes.
judge, where the court said that the order for earlier production has become infructuous, then
Infructuous on the basis of what?
saying that the
On
date
on
has
basis-
passed, the date has
he
already
could,
passed.
He could not produce, and on the basis of my IA 483 for recalling of the application which the ED has passed, that is IA 465.
Oh, that also was disposed of.
That yes, 465 they have filed for production for the purpose of custodial interrogation.
So isn't the effect of this order doesn't it dispose of both?
Which board?
Their IA 465 as well as your IA 483?
No.
The
Disposed
effect,
of 4/8/2025. That is IA 465, my lord. Kindly see at page 36 again.
yes.
This is IA 465.
This is for recalling.
Yes,
This
recalling.
is for recalling the warrant.
No. This is not recalling. This is the order that has been passed.
I mean your order.
My recalling is at page 38. 36 is the order that has been
Okay,
passed on a
okay,
base of an
okay.
application
Okay,
filed
yes.
under 267 by the
Verse
ED.
43.
Yes. So kindly see 37 at page 37, according application IA 465, is allowed and disposed of. What you got it? Now I came up before the court for recalling of this recalling of the order at page 38.
And your IA 483 was for recalling of this
Yes.
4/8/25.
Yes.
Okay.
464, that is page 38. Lordship got it, my lord?
So in your submission,
Yes.
you say that a fresh application ought to have been filed.
Number one. Now number two, now, jail authorities is not investigating. ED has to come up. ED has to.
Jail authority cannot.
Yes.
But-
And secondly,
So-
ED has to file a fresh application before the special court that yes, I want this person production to be produced before the court for the purpose of whatever the purpose may be.
For investigation.
Maybe investigation,
Because
whatever may
it's-
be.
Because it's for any, if it's
Now-
for
now
any
my lord-
other proceeding,
Yes, yes,
during the
correct.
proceeding.
Right, correct. Your
No
lordship-
application is
yes.
required. The court can so more to issue the production warrant.
Now, but my lord will kindly see one thing is very, very important. Now, if your lordship looks into it, there are two stages. One is a pre-cognizance stage and one is post-cognizance stage. Pre-cognizance stage, yes, the ED has got the power to investigate and for the purpose of arrest. But for the post, under section 19, but for the post investigation, when it is post, my lord, cognizance has been taken of the complaint, then it is the hand of the special court. Because they become a powerless under section 9 for the purpose of arrest. Am I clear to your
So
lordship?
which stage is it now?
Now
The
there is a
case?
post cognizance. It is a post cognizance. Why I am saying, my lord will now kindly see the petition. See the petition now. Now, if your lordship looks into page 89, this matter has been decided. See page 89. Before that, your lordship will look into the order. This is very important. Kindly see order of
Page 89, order dated 21/7.
yes, the order of the High Court where we have challenged the order of the non-bailable warrant. My lord, I'll tell you one thing. This is the procedural part. My lord, I'll just connect your lordship. It will be easier. A money laundering case, they started ECI investigation. Thereafter, they file a complaint. It's like a summon procedure. So they file a complaint under 200 and according process was issued. Your lordship will see that process which was issued is at page 41, kindly see, my lord. 41. This will clear the whole thing, my lord. 41. See 41. 22/3/2024, a complaint under section 44 and 45 of so and so received along with the report of investigation in the form of charge sheet for the offence made punishable under so and so. From the perusal of the charge sheet and accompanying material placed on record, there being a prima facie case, cognizance is taken. For the offence of money laundering, case record is taken up for file. Register this case as money laundering case number 01 of 2020. Issue summon to all 299 accused persons made returnable for supply of copy. So all this started now at page 42. Page 42, if your lordship looks into it, page 42. For the accused who is a petitioner, at paragraph 3, para 3, 24/5/2024 at page 42.
Page 42.
Page 42. Mr. So and so, learned counsel for accused number 1. 1 is a present petitioner here in this case. Is so and so. So he was represented throughout. Absolutely, there was no problem. Now, my lord will kindly see. Now, kindly see in between, they file an application at page 44. Kindly see page 44. Page 44. This is an order on 2/7/2024. An application was filed by the ED, my lord, and IA 230, your lordship will kindly mark, which is most important. 230 of 2024, they filed, what was that case? To issue an open-ended non-bailable warrant against the present petitioner. To issue open-ended non-bailable warrant against so-and-so, and this order was an ex parte order. How your lordship will find? Your lordship will find at page 53. 53. See 53, my lord. Now 53 is the order, that is 2/7/2024. Lordship got it? This is an order. Now if your lordship looks into it at page 55, see 55, after paragraph 3, my lord, subpara, after paragraph 3 subpara.
55.
55.
Sir, you're referring to which page of which volume, sir?
55.
Page 55.
55
Of which volume?
of my petition. Petition.
Revision application.
Yes, yes.
Okay.
Criminal petition, no, criminal petition.
Criminal petition.
30, item number
Petition
28.
30.
28. So now kindly see 03 at paragraph subpara. As such, from the aforesaid, I am satisfied the accused is not cooperating with the investigation and that his presence before the investigation is necessary, and now it is shown accused is absconding and stationed at Dubai, the prayer for applicant being allowed. Accordingly, in view of the aforesaid reasons stated, the instant application allowed, an open-ended non-bailable warrant of arrest is hereby issued against so and so, so and so. Above observation, IA 230 of stands allowed and disposed of accordingly. So this is also an ex parte order. Now we came up before this court for recording of that order, and at page 61, kindly see, the order was recalled by the court at page 61. Kindly see the order. That is 5/9/2024. Lordship can see onto it. Page 61. Now, if your Lordship looks at page 64, page 62 kindly see for a moment, one judgment was quoted, page 62. The entire order, 62 is quoted by the learned special judge. See next paragraph, in Tarsem Lal was a director of enforcement so and so. The para 30 was quoted. Once cognizance is taken of the offence punishable under section 4 PMLA, the special court is seized of the matter. After the cognizance is taken, now kindly mark, ED and other authorities named in section 19 cannot exercise the power of arrest of the accused shown in the complaint. The reason is that accused shown in the complaint are under the jurisdiction of the special court dealing with the complaint. Therefore, after the cognizance of the complaint under section 44(1)(b) PMLA is taken by the court, ED and other authorities named in section 19 are powerless to arrest an accused named in the complaint. Hence, in such a case, an apprehension that ED will arrest such an accused by exercising power under section 19 can never exist. Now, if your Lordship turn to page 64 now at 05 on the top, 05 on the top, see, I have considered the above rival submission advanced by learned counsel for the parties. It is a fact as pointed out by the learned counsel for the accused petitioner. Present accused was not shown as absconder in the instant complaint. Please mark, not shown as an absconder. It is also fact, application of the ED praying for open-ended non-bailable warrant was heard without giving any opportunity to the accused petitioner. In Tarsem Lal, the Honorable Supreme Court era para 31, now he goes to 31. If ED wants custody of the accused who appears after service of summons for conducting further investigation in the same offence, ED will have to seek custody of the accused by applying to the special court. After hearing the accused, now kindly mark, after hearing the accused, the special court must pass an order on an application by recording brief reason. While hearing such an application, the court may permit custody only if it is satisfied. Custodial interrogation at that stage is required even though the accused was never arrested under section 19. So, my lord, application has to be filed.
That's why I was asking you that they'll have to file a fresh application.
That is why I want to show it, my lord. More dangerously they have done it. That is why I am troubling your lordship. How they have violated. Now kindly see next, page 64, next paragraph. In the instant case. See, in the instant case, the accused petitioner was not arrested during the course of investigation as he was absconding and evading arrest as claimed by ED. But he was not shown as an absconder. Be that as it may, ED can still seek custody even though the accused was never arrested. But after hearing the accused as per Tarsem Lal, as noted above, application of ED praying for open-ended non-bailable warrant of arrest was heard without affording any opportunity to the accused. As such, I am of the opinion that the application of the ED praying for open-ended non-bailable warrant of arrest be reheard, giving an opportunity of hearing the accused petitioner. Application of ED will be reheard on the next returnable date on 18/10/2024
On the Telegram,
Can you just pause? Just mute, please. The application of the ED
I'm
will be
sorry,
reheard.
I was not aware. I was not aware that I was.
Yes, yes. Thank you. Thank you. The application of the ED will be reheard on the next returnable date, which is fixed on 18/10/2024. ED to supply a copy of the application to the accused petitioner through counsel. Meanwhile, the non-bailable warrant of arrest issued against the accused petitioner, namely Bhupesh Arora, is kept in abeyance till the next returnable date. The accused petitioner is to be personally present on the next date. With the above observation direction, instant IA number 531 of 2024 stand disposed of accordingly. Now, my lord, now can see at page 76 now. Why we have to come to the High Court? Because of an order of 1312. Even there was an order keeping in abeyance. My lord, see page 76, which is now pending, which is one of the items which has been listed today.
Okay.
Now, item 17. Now, kindly see Criminal Division 3. My lord is 21-3. Mr. Das, so and so, learned father has submitted. My lord, we will read the entire order, you will understand, my lord. By the order dated 7th of March 2025, by order dated 7th of March 2025, 4 weeks time was granted to ED for filing written objection against the revision petition. Now, my lord, 4, he submits the instant revision petition. Petitioner has the impugned order dated 13/12/2024, passed in ML number 01/2024 by the learned special judge, whereby by non-bailable warrant of arrest was issued against the present petitioner. The learned senior counsel submitted main ground for issuance of non-bailable warrant of arrest against the present petitioner was that the petitioner failed to appear in person before the court in pursuance to the order dated 5/9/2024, passed in IA number 531 of 2024, which your lordship has just now I have read, that 59. The learned senior counsel for the petitioner submitted before registration of IA number 531 of 2024, trial court had on an application made by the learned special public prosecutor ED on 2/7/2024 in IA number 230 of 2024 had issued non-bailable warrant of arrest against the present petitioner without giving an opportunity to learned counsel of the petitioner of being heard. The learned counsel for the petitioner has also submitted ML number 01 of 2024 after submission of the charge sheet, summons the accused to 299 numbers of accused person, including the present petitioner, and after receipt of the summons, the petitioner engaged counsel has been appearing before the trial court regularly. He also submitted that in the charge sheet the petitioner has been shown as an absconder and no pending warrant was issued against him during investigation. The learned senior counsel for petitioner has submitted that by order dated 5/9/2024, passed in IA number 531 of 2024, the trial court kept the non-bailable warrant of arrest issued against the petitioner by the trial court on 2/7/2024 in abeyance and directed the ED to supply the copy of the petition filed by them in IA number 230 of 2024 to the petitioner, fixed the matter for hearing on 18/10/2024. By the said order, petitioner was directed to be personally present on the next date, that is 18/10/2024. Learned senior counsel petitioner has submitted that on 18/10/2024, engaged counsel for the petitioner were present in the court, submitted before the court as an IA number 230 of 2024 is pending for disposal, and copy of the said IA has not been furnished to the petitioner. Court directed the learned special public prosecutor to furnish the copy of the said IA and fix the matter for hearing on 12/12/2024. In the meanwhile, the interim order dated IA number 531 of 2024 was extended till next date. The learned senior counsel for petitioner has submitted as the non-bailable warrant of arrest issued in pursuance to an order passed in IA number 230 of 2024 has been kept in abeyance, and as the personal appearance of the petitioner was dispensed with by the trial court, on 18/10/2024, there was no occasion for the trial court to issue non-bailable warrant of arrest on 13/12/2024. Hence, he prays for staying the operation of the impugned order dated 13/12/2024 till the next date, and also prays for keeping the warrant of arrest issued against him by the impugned order in abeyance till next date. Considering the submission made by learned senior counsel for the petitioner, learned so and so, for filing so and so has no objection. Considering para 12, considering the submission made by the learned senior counsel petitioner, prima facie it appears that the order dated 5/9/2024 has not been violated by the petitioner, and still the next date fixed, the operation of the impugned order dated 13/12/2024 shall remain state, and a non-bailable warrant of arrest issued in pursuant to the impugned order shall also remain state till next date.
Okay, so the NBWS state and it is still pending.
Still pending. So whether by way of this application, production warrant for the purpose of custodial interrogation, whether they can do it or not. Indirectly, my lord, they are trying to arrest me where a stay order has been passed by the High Court. Now they tried. How they tried, my lord? Kindly see the order. They filed an IA at page 89. See 89, they filed an IA. Before they went before the learned trial court to file an application under 267 at page 89. Kindly see, my lord. ED tried to circumvent the order in a circuitous manner. Kindly see page 89. 21/7/2000. Heard so and so, learned so and so. This is for the ED, learned counsel. Also heard Mr. Didas. IA files. This was filed by ED. Your lordship will kindly mark. IA 13/2025 was filed by ED in connection with 3/2025, which I read now. They filed, ED filed.
13/25 is filed by ED.
ED in connection with 3/2, which an interim order was passed, your lordship. I have just read. Non-bailable warrant has been stayed, my lord.
Connection with,
Has been stayed. Non-bailable warrant of arrest has been stayed. Now, if your lordship once again see at page 79, kindly see non-bailable warrant has been stayed.
so what was this IA
No,
for?
yes, now you see. IA has been filed. If your lordship see 89, on the last, IA has been filed with two prayers. Kindly see page 108. Page 90. Page 90. IA has, page 89 is the IA.
Yes, to allow the present application.
Yes, to allow the present application seek for urgent hearing of the connected criminal revision petition 3/2025. That is what your lordship has read the order. In view of the subsequent development in connection FIR number so and so, Faridabad. Now number 2 is important. For clarification of the order dated 7/3/2025, all different orders, and also with the additional prayer, the said order do not put any embargo on the excess of the power under section 19 of the Prevention of Money Laundering Act 2002 PML. Now, my lord, this is what was established. Where is the question? Under 19, you don't have the power to arrest. Your lordship have looked into it. Post cognizance only is a post. Now, if it comes before the court, complaint has been filed. Pre-investigation you have. Tarsim Lal judgment says you don't have any power. You become a powerless. You can see the wording. I put the judgment also. I'll read that. How the court dealt, kindly see.
So according to you, now only way out is to file application
Yes.
by the ED.
Yes.
And the court will allow.
And court will hear us, give a notice to
and
us.
may allow, may not allow.
But the notice has to be given to us.
Notice to be
For
given.
hearing. That is, cannot be an ex parte order. Cannot be an ex parte. Now your
Okay,
lordship.
we issue notice.
My lord, now my lord, kindly see for a moment.
Yes,
If the custodial, the purpose behind your lordship has seen that warrant of arrest has been
No,
stayed.
we will state.
Yes, where is the question? That means they want to put in custody.
We will hear the answer. Yes. We will give
My lord,
you
may I
opportunity
make
to
my
file
submission?
for- Yes. Yes.
If my ladyship is not granting any stay, it's fair enough, but otherwise I may be heard.
No, we will have to grant a stay at this stage. We will give you a short.
Then my ladyship may hear me.
Okay.
Hear me before now. In a criminal case, custody is different from production. He is required to be heard at the stage of granting custody, not at the stage of production. He has been asked to be produced. The production is
Learned Counsel, your audio is not good.
when an accused in jail for some other offense, and when the accused appears, the concern is under the old 167 because you cannot apply for custody. So, for the purpose of production, an application, either the police arrest or the ED arrest and brings him to the court, that is production, or if it's in some other jail within some under the competence of some other court, then the production warrant is issued. So, production warrant has nothing to do with hearing. Is only being produced instead of that court is being produced here. And if remand is to be granted, if
But the
custody is to be
production
granted,
warrant,
it is
Learned Counsel,
that stage that hearing is to be
the
made.
production warrant was issued on the basis of an application filed by you for interrogation, for custodial interrogation.
Fair enough. He was, yes. No, it was not allowing us to take custody for the purpose of it. That's the second stage. For getting custody for interrogation, if you want custody, then there are two things. Interrogation is different. Interrogation under custody is different. So if you want interrogation under custody, we have to apply for remand. Kindly have a look at 167 and the second is 187 BNSS. My ladyship would like me to read 167 or 187 because both are identical. Kindly have a look at 167 first. It is similar to 187 of the new code.
In BNSS?
BNSS 187. I'll read BNSS 187. So for custody,
Yes, 187.
which is equivalent to the old 167, whenever it is, but there are two ways of, there are more than one way of producing an accused and asking for his custody under 187. One is when I arrest him. Whenever any person is arrested and detained in custody, appears that the investigation cannot be completed within a period of 24 hours, fixed under section 58, and there are grounds for believing that the accusation or information is well founded, the officer in charge of police station or police are making the investigation, if he is not below the rank of service, shall forthwith transmit to the nearest magistrate copy of the entries of case diary hereinafter specified relating to the case, and shall at the same time forward the accused to such magistrate. So forwarding of the accused to the magistrate is necessary before any remand orders or custody orders are passed. The forwarding of an accused has nothing to do with hearing. It is remand that is, or custody is that to do with hearing. Now kindly have a look at 2.
No, fine, understood. For remand, no application is necessary, nothing is necessary, only the court will remand. When it's
No,
ready.
for remand application is
But-
necessary. We have made a separate application for remand where he will be
That is
heard.
different. But your application, see your
Now
application.
kindly have a look at subsection 2. Yes.
Yes.
My application says that he should be produced before he should be. Kindly have a look at my application. That is IA 483. What is that?
Their application was
Page number. Huh?
19.
Huh? Page
99.
Kindly have a look at page 99.
99.
IF of production.
Yes.
Now kindly look at this. Application under at page, I'm reading page 100.
Application under section
Section
267.
267 CRPC corresponding to section 302 of PNSS read with section 65 PMLA seeking production of the accused. So we are seeking production of the accused for the purpose of applying for a custody. So first stage is produce him, then only I can apply for custody. So this is an application for production. Now kindly look at the prayer. 126. So I said, because without production, I can't take custody. So first produce him. Unless the accused is produced before the magistrate can't grant me custody. So I have to say that why am I asking his production? I am asking his production so that in future when he's produced, I'll ask for his custody. And Tarsim also says that, I'll read, my learned friend has not read the relevant provision of Tarsim. Kindly have a look at 126. Prayer.
Yes.
Issue
Issue production warrant for such and such to produce the arrestee before this court under 267/302 as custodial interrogation of the accused is required. Yes, can you hear? Learned Counsel?
Why? Yes.
So you prayed
So
for
that
production and this was allowed and disposed of.
date. We have said ask him to be produced. Our application is not for producing on a particular date. Our application is custodial. So when it's produced, we'll make a custodial now because it's produced. So that is not, so our is not, we have not asked for custodial interrogation. No, we have said that's different from asking him custodial interrogation. After he comes, we'll apply for custodial. Am I audible?
Yes, now you're audible.
Yes, so many people are logged in. Switch off all the offices. So if I want to take custody of the person, am I audible now, Your Lordship?
Yes, yes, now it's okay.
If I want to take custody of an accused person, I can't take custody unless it's produced before the court. Password here.
No, I understand. What you're saying is perfectly fine. But what I'm trying to tell you is the IA which you filed for production is disposed of. It was allowed. But the court learned trial court.
It was allowed. In that
Yes,
in
it was
that IA,
allowed.
I have not asked for in that IA, I have not asked for any particular date for him to be produced. I only said kindly produce him. Kindly look at my prayer. I never said that produce him on X day, Y day. Now kindly have a look at the order.
But come to the impugn order, the court
Yes.
said that the learned trial court said that it's now infructuous.
Because the order. Now kindly have a look at the order.
When the court says it's
Page
infructuous,
39.
don't you have to
No,
file a
that's
fresh
order on this
application?
Order on this application. No, it's not required. Because my application is not for a particular date. The order is for a particular date. The order may have become infructuous, but kindly have a look at page number 8, 17 or 8. 8.
97.
97. Kindly have a look at 97.
97, yes.
Logistically not possible, but because of independence.
Page 97, yes.
Yes. Now kindly look at 98.
Yes.
Issue the operative portion. Issue production warrant directing Superintendent Tihar Jail, Delhi to produce the accused before this application 11/8. So the order says produce on 11/8. I never asked the court to produce on 11/8. I only said kindly produce him on any date you want. The court says, all right, I'm producing on 11/8. Now 11/8, usually it happens, it is routinely happening in courts that on that 11/8, the Tihar jail may not have facilities. So they will say, sir, we cannot produce on 11/8, we'll produce on some other date. That is a routine thing. For that, I don't have to move a separate application. The order is passed for production. If it's not produced on that date, the Tihar jail will give an explanation and they say we'll produce on the next date. That is between the Tihar jail and the court. The date is given only for convenience. It is not a fixed date. Supposing on Tihar jail they are coming and the train is delayed. They say we are producing on the second day.
Shortage of time.
Now kindly look at why he says, because of shortage of time. So anyway, the court wanted the production. The court did not. My prayer was not producing on a particular date. My prayer was to produce on any date. If the court passes an order giving a fixed date, it doesn't make my application infructuous. My application is not for a fixed date. It is only if my application is for a fixed date, it becomes infructuous. Therefore, the order could not be affected because it's not produced. Therefore, you
Yes.
say producing
So
on
what
the
you're
next day.
saying is, after that, the court has the power to fix any other date.
Any other date which is done. It is a matter between the jail authorities and the court. I have nothing to do with it. My application, the order producing the accused has been passed. That order is not challenged. That order has attained final. It says when is to be produced is between the court and the jail authorities. Jail authorities say that we don't have enough escort. We will not produce. The accused is sick.
Became infructuous. The court records the order is not an application.
Our
Justice Surana is leaving now, and we have a division bench matter.
Yes.
He wants to pronounce the judgment.
But your lordship can do it
Just
because it's 16 is the date. So your lordship will for time being.
No, I'm objecting. He has absolutely no case.
This order,
No.
hear it on Monday.
He can't take advantage.
Hear it on Monday. How heaven will fall, my lord.
Production
It is
is
a-
for 16th.
For 16, they will bring on Sunday from there.
Can we hear,
16
can,
will
can we
apply for
continue,
custody. Court may grant.
Yes.
can we continue the hearing on Monday?
Monday we can.
Yes,
I have no
because
objection.
production is for
Monday,
16th.
Monday, yes.
So, my lord, what they
Monday, anytime. I'm ready to conduct the
No,
matter on
they
Monday.
will try to move it, this accused person on Sunday itself, making it infructuous to bring it, that's why I'm saying.
No, custody is
My lord,
different
can
from
kindly stay
production.
there. Stay till
No.
Monday, your lordship will stay. Thereafter,
There
your
can't
lordship
be
will
any stay.
think
I'm sorry.
that
It is
required till Monday,
just
your
because.
lordship will stay.
No, I have a very strong
Till
case. I am
Monday.
objecting to this. There is
Monday
absolutely no
will say,
case.
no matter objection
All
can be
judgments are in
recorded.
my favor.
Yes, Monday, my lord, till Monday it can be stayed, and thereafter, my lord, your lordship will hear it.
Then
Later,
the
your
jail
lordship will find it
arrangements are
out.
being made for
Yes.
Delhi. All these
4
arrangements can be
2025, these orders have also been put to challenge. My learned friend said, not been,
Yes,
we
yes,
have
yes.
put to
Okay,
challenge.
Wait. We will stay till Monday then.
Till Monday, yes.
We'll hear you on Monday.
Yes, right.
This is.
No, I'm sorry. As far as
Yes,
where the question is staying, the
I'll
matter is on
record your
16th.
objection.
Yes, record the
Yes.
objection.
My ladyship may kindly have the matter is coming on 16th, where the purpose of granting stay till Monday. But Monday the matter will be decided.
And we have filed
There's
the
no stays required for Monday.
Either
Nothing is
the
going to
stay
happen
will
on
be
Monday.
lifted. Either the stay will be lifted or it will continue.
Yes.
No, but there's no requirement of granting stay. There's no requirement of
No,
granting stay.
today the court has
Nothing is going to happen till 15th.
Yes.
Nothing is going to happen till 15th.
Yes, it will
Nothing is
happen.
going to
They
happen till
will
15th.
try to move
Once
and
your
they will
ladyship
try to
says,
make,
then the matter
they are trying
will not be
to,
heard.
influence,
No.
High Court's order
I'm
has been
sorry.
violated.
Okay. I'll pass necessary order. Okay.
Yes.
I
I'm
pass
deeply obliged.
necessary order.
I'm deeply obliged.
No, I have to be heard. I have not yet been heard, your ladyship.
How can I hear you
Can it be
now?
heard in the
That is
later
the problem.
in the second half, my lord? Can it be heard today in the later half?
This court is rising at 12:30 today.
Oh, I'm so sorry.
Yes, that is the whole problem.
We have already filed that
Let
application.
it be kept.
But
We have already filed an application for taking custody. He'll get a right to oppose it. He'll get a right to oppose it.
No, there cannot be. Let him.
No, what do you mean? No.
See, if I'll pass the order, either I pass the order or it can be heard on Monday.
Yes.
It's up to you.
Monday,
Monday.
Monday, the learned ASG is available, he said. It can be put on Monday, my lord.
Monday?
Can be put on Monday, no problem.
No orders.
No, if it
Monday,
is not.
pass over to
No,
Monday.
then this person will be brought. He will be brought and he will become infructuous, my lord.
There's still time, 1 day is there.
No, he will be brought, my lord. My application become infructuous, my lord. I am asking only
It
till
don't become
Monday.
infructuous.
No, it will become. They will move this person on Sunday from Delhi.
It can be heard on Monday,
The
it can be heard
application
even
will become
tomorrow.
infructuous. That is why they are. That is why there is an objection
Without
from the
hearing in
side.
custody will not become
Only they
infructuous.
want
No, it
that
doesn't become infructuous.
this
It's
application
fully
should
produced.
become infructuous.
Anyway, yes,
My lord, I
it
am
doesn't make any
asking for
difference.
1 day. Till
Production, you have no
Monday,
right. I'll
this
demonstrate
order,
production, you
the
have no right to
production
ban
warrant
law.
should be stayed. Till Monday, 1 day I am asking, my lord.
No.
What makes them
No.
difficulty, my
I am
lord?
objecting.
And the High
Nothing is going
Court,
to
there is
happen
an
in
order
production
passed by the
warrant.
High
Nothing is
Court.
going to happen.
Okay.
It is.
Till Monday, if you want to file an appeal or something, you file. Otherwise,
Fine.
I've made up my mind. Monday, till Monday.
Yes, I'm deeply
Monday.
obliged. I'm
Yes.
deeply
Grateful. I'm obliged.